exercised judicially.
And what is the difference in requirements between the test for interim relief and test for final relief?
In an interim interdict, the applicant has to prove a prima facie right, real harm or the apprehension of harm. The balance of convenience must favour the granting of the relief, and then there must be no suitable alternative remedy. In final interdict applications, you have to prove, or the applicant has to prove a clear right, and then also again the harm or a reasonable apprehension of harm, and finally no suitable alternative remedy.
Is there any contribution you have made as an advocate to the transformation of the legal profession?
I certainly believe I have done so, Chief Justice. It is something that is very close to my heart. I have been mentoring my black female colleague for the past 6 years, actively mentoring her, and I'm proud to say that she is also now acting in our division. I also mentor young female and black attorneys almost on a daily basis. I will get telephone calls from them asking me for advice or assistance. I do a lot of pro bono work. I devote 20% of my practice to indigent people. I also lecture. I lecture on conveyancing and notarial practice. I've been doing that since 2005.
Thank you. Judge President, I now give you the opportunity.
Thank you, Chief Justice. You've actually taken my script. But be that as
Sorry.
it may, be that as it may, good evening, Advocate
Good
Stanton.
evening, Judge President.
Yes. What you did not highlight is that you are also a conveyancer and a notary public.
Yes, I
a
am.
qualified one. Yes. And you did mention that you sat on criminal appeals.
Yes, I did.
Which would really cover you. So most of the ground has been covered. Your CV is quite clear. It sets out who you are. And I remember when I first invited you in 2018, you were hesitant to come. But here we are now. You did sit for all those things. One thing that I have noticed again is that you did some training in Northwest, training in the establishment of Communal Property Association.
Yes, I did.
And you established them.
Yes.
Yes. And in the Northern Cape, I've noticed that we are inundated with such applications in our court rolls. Have you just given a thought as to what causes these disputes? Because these are the lands that have been claimed back for the communities, but we do have a lot of conflicts and litigation. What could you have established could have been the problem?
And I don't want to step on any toes,
Yes.
but I think the communal property associations need training and assistance. I think if they understand their mandate properly, if they know how to manage the communal property association, which includes convening meetings in a proper fashion, holding conducting and holding correct meetings, keeping resolutions, that would issue out a lot of the problems for the communal property associations.
Does this big business and commercial entities not contribute also to these conflicts by causing factions and divisions amongst communities?
They unfortunately definitely do. And I think that the communal property association should be skilled to prevent them from being taken over by these big commercial entities, from insisting on what is due to them is due to them for their benefit.
I see. And then you did mention that there's a case, Khai Etelwe,
Yes.
which you still had to deal with. I did check, I found that you gave a judgment in February.
Yes, I did, Judge
On the
President.
merits. What is only outstanding is quantum.
That's correct.
The parties are free to set it down for quantum unless they settle it.
That's correct, Judge President.
I think my script has been covered. Thank you very much.
Thank you, Judge
Chief
President.
Justice.
Thank you, Judge President. I now give the Premier the opportunity to put questions to the candidate if he has any. Premier? Premier, can you hear me? Oh. Secretariat, can you call the Premier and see if you can find out what's happening?
Chief Justice, he doesn't seem to be online at the moment.
Oh. Hey, this time virtual is not, has got problems. Yeah, last time I was here, it didn't give us so many problems.
Chief Justice,
Yes.
while we are waiting for the Premier, can I ask something that arose from your questioning? There is something that the candidate said, and I really want to clarify it.
Okay, just one question.
Yeah, just one question.
Yeah, okay.
Good evening, Judge.
Good evening, Commissioner.
I was quite concerned when you were asked about the test for 174 for discharge. That provision is probably one of the shortest provisions in the Criminal Procedure Act, and it's very difficult to get it wrong. I just want to understand, does the concept of guilt,
Chief Justice, and I'm sorry to interrupt the learned Commissioner. I think it might not be proper to continue while the Premier is not part of the meeting because we are not.
Yes. No, you are right, yeah. Let's wait for the Premier. I think it arises from to try and use the time. But let's wait, yeah. Yeah, we'll just wait for the Premier.
CJ, it's just that I don't know how this quorum thing works.
Yeah.
Because she's in the meeting, it's just that the system kicked her out. It's same like when, for example, the Premier steps out to go to a bathroom. Obviously, that would not necessitate that we adjourn. I don't know.
Yeah. Hey, well, at least we can watch you if you go out.
No, I agree with
back. If this one, we don't know when he comes back, when he doesn't. We might have covered a lot by the time they come back, yeah. Yeah, it's safer, yeah. Advocate Stanton,
Chief
the
Justice.
Premier's question is, what is your take on the complaint that is made from time to time that the judiciary is overreaching?
Thank you, Chief Justice. Thank you, Premier. I do not agree with respect with that submission. I think that the judiciary is very careful not to overreach and interfere with the doctrine of separation of powers, and that they only would do that after the clearest case is made out for that to happen, and if it is constitutionally appropriate to do so. So I do not agree with that.
Yeah, when the next candidate is here, if the technology is still giving us problems, you will be in touch with the JP and we will do the same. Okay, thank you. Okay, bye-bye. Bye. He says the technology is giving him problems, but I thought let him put questions in this way, and we'll do the same with the next candidate. He will see how the technology goes, but he will put questions in the same way. Okay, all right. That's the only question he wanted to put. We have put all the questions. It was going to be the three of us. There is just one that I thought I had already allowed Commissioner Marumo Wahena. Wahai. I've been getting it right of late, but now.
I think we're going to find you now, Chief Justice.
Hey, I've no money.
Sakudli kusha.
Please go ahead, Prof.
The question that I wanted to ask you, it was in response to your answer to what is the test for a discharge. Having regard to what you answered, or what your answer was, if somebody was to say to you that perhaps it's not the test, and the test is the court has to look as to whether there is a prima facie evidence that if the accused will be placed on the stand, the accused will actually be doing the work for the prosecution and they will be incriminating themselves. Will that be the correct test for?
That is correct as formulated in State versus Lubbock.
All right, no, thank you. Thank you, Chief Justice.
Thank you, Prof. Okay, we are done then with this interview. I think Advocate Stanton will now excuse you. Thank you very much.
Thank you, Chief
You are
Justice.
now excused.
Thank you, Commissioners.
Thank you.
Thank you.
Good evening, Ms. Venter.
Good evening, CJ, JP, and Commissioners.
How are you this evening?
I'm a bit tired. I can't remember. In the last 20 years, I've been awake this time of night, but I'm here.
I apologize that we didn't interview you at a time when we all expected we would interview you, but it was because the other interviews took longer than expected. But do you mean by now you would normally be in bed?
Yes, I'm an early morning person, not an evening person.
And you'd rise, you'd wake up around what time in the morning?
4 o'clock in the mornings,
Oh, okay.
every morning.
Okay. Thank you very much. Yesterday, this commission adopted selection criteria for the appointment of judges, and it committed itself through the document dealing with those criteria that while on the one hand, commissioners would be robust when it's necessary, but at the same time, they will have due regard to the dignity of candidates, and they will deal with them with respect and courtesy. So everybody who's here wants to make sure that the candidates are treated fairly. I'm going to ask you some questions. After I've finished, I will ask the JP of the Northern Cape Division to ask you questions, and after that it will be the Premier, and we will then take it from there. Tell us about your academic qualifications.
I have a B.Juris degree and an LLB degree, and I've completed 3 courses of my LLM degree, but I didn't finish it.
Is it the dissertation that is left?
I beg your pardon?
Is it the dissertation that is left?
Yes, it is a dissertation.
Okay. When did you get your B.Juris degree? When did you get your LLB degree?
B.Juris degree at the University of Pretoria,
When?
1982, 83.
Okay. And your LLB?
My LLB, University of South Africa, UNISA.
Yes. Okay.
That was quite some time after that, 1999.
Yes. In 1988, you were appointed as a district magistrate, is that right?
That is correct.
District court magistrate. Prior to that, did you work as a prosecutor?
I was a district court prosecutor for 2 years and a regional court prosecutor for 3 years.
Yes. And then in 2003, you were appointed as the regional court magistrate.
That is correct.
Between 1988 and 2003, what other positions did you hold? That's a long period.
Yeah. Apart from being a magistrate in Pretoria, Durban, Mpumalanga, I was also the judicial head in Sasolburg.
What were you in Sasolburg?
The judicial aid.
What is that?
I was like the senior magistrate at Sasolburg in control of 4 or 5 additional magistrates.
What is it called?
Judicial aid.
Or judiciary head?
Yes.
Oh. Judiciary head. Yeah, no, I'm sorry.
I've got a terrible cold, so I'm trying my best.
As a district court magistrate, did you do both criminal and civil cases?
Not in Pretoria and Durban, but in Mpangeni and Sasolburg. I've counted it in a total of 8 years. I did only civil work.
Or as a district court magistrate?
That's correct.
Okay. And as a regional court magistrate, I guess that for a long time you would have done only criminal cases.
Yes.
Until the regional courts got some civil jurisdiction.
When we got civil jurisdiction in 2010,
Yeah.
I counted it from then until now. I've done 103 civil trials, which included opposed motions.
Yes.
And I've done 1,415 divorce cases.
Yes. Okay. Now, you have acted in the High Court.
That is correct.
When was your first acting stint?
I only had one stint, and that was in 2019.
And how long was it?
9 weeks.
9 weeks.
Yes.
During that period, did you sit in motion court?
I did, if I remember correctly, 2 opposed motions.
Only 2.
Only 2.
And did you do unopposed motions?
Unfortunately not.
Yes, and did you do civil trials in the High Court during that time?
Unfortunately not.
Did you do criminal trials?
Yes, I did.
How many?
I think 4 or
About
5.
And how many judgments have you been able to write during, were you able to write during your acting stint?
The 4 or 5.
4 or 5?
Yeah.
But the number of cases that you had was much more than that?
At the end of my stint, I only had 1 case left that was part heard.
But during that acting stint, if you count both criminal matters and civil matters, motion matters,
Yes, I
altogether,
wrote,
how many matters had you done, if you are able to share that with us?
all in all, it was 7 or 8 written judgments.
Yes, that's the number of cases that you also had.
Yes.
Yes. And out of these, you say there were only what, 2 motion matters?
And 1 Rule 43.
Yes. In the regional court or district court, were you able to deal with interdicts?
Yes.
Yes. And when you were acting in the High Court, did you get a chance to sit in appeals?
Yes, I did 1 appeal, 1 or 2, maybe 3.
Yes.
One was a full 3 judges. I was one of the 3.
Yes. So your appellate experience would be limited to those cases?
Yes.
Yes. And your motion court experience at High Court level would be limited to those 2 or 3 cases?
That's
motion
correct.
Court. But in the district court and in the regional court, did you do, or do you do motion matters there as well?
Yes, I did.
Yes.
The district courts in Mpangeni as well as Sasolburg are very busy courts,
Yes,
as far as civil matters are concerned.
yes,
Since I've been in the Northern Cape and since 2010, one must take into consideration that the area where I'm residing and where I'm the magistrate, it's really poor people. And so those people do not litigate that much. But all in all, of the 103 cases that I've done, I've made a call to the district magistrates in those 10 courts. And combined, they haven't even done that much.
Now, you have not done a lot of motion court at High Court level, but you have done it at district court and regional court level, is that right?
That's correct.
Yes. Are you familiar with different types of discretion?
Different types of,
discretion?
I beg your pardon?
Are you familiar with the different types of discretion?
I don't think I understand your question.
Okay.
I'm a bit hard of hearing, so
Yes,
please
okay,
excuse
all
me.
right. No, I'll try and speak up. when you adjudicate cases, have you heard that sometimes it would be said this judge or this magistrate was exercising a discretion in making this decision? Have you heard anything like that?
Yes.
That's what I'm talking about. Are you familiar with the different types of discretion?
Discretion.
Yeah.
Yes.
Yeah, share with the commissioners what the different types of discretion are.
I would start by saying that it is very important that you understand the facts to be able to identify the issue and the point of law. As far as the discretion is concerned, my discretion lies with summing up the facts, evaluating the facts, applying the law, and at the end of the day, have a judgment ready. I hope that answers your question.
What is the test for a Section 174 discharge in a criminal matter?
The test, as far as Section 174 is concerned, is not, you're not dealing with the credibility of the witnesses, but if there is no evidence on which a reasonable court can convict, then you should apply your discretion in favor of the accused person and find the person not guilty and discharged or acquitted.
You might not be able to deal with this maybe because you have not had much exposure in terms of sitting on appeals, but it may be that you are familiar with it from your reading. If you are sitting on appeal in a matter, hearing an appeal with other judges, and you are called upon to overturn the factual findings of the lower court, under what circumstances can you overturn or interfere with the factual findings?
One will not easily interfere with the factual findings, especially as far as the evaluation of the evidence is concerned, unless the discretion was exercised totally wrong, then you will interfere.
Yes. And what is the difference in requirements between the test for an interim interdict and the final interdict?
As far as the interim interdict is concerned, you'll have to be convinced on the papers in front of you that there are sufficient grounds to grant those. As far as the final interdict is concerned, and now thinking about it, I've dealt with one final interdict in the High Court. There you would apply let me just remember again. There you will apply the test that you need to look at the facts, especially where it's an urgent interdict, whether you can settle the matter on the documents in front of you, or whether you should refer it to evidence. But in most of the cases, especially where it's an urgent interdict, you will try, as to the best of your ability, to deal with the matter on the papers in front of you.
What contribution have you been able to make towards the transformation of either the legal profession or the judiciary, if you have had some contribution that you have been able to make?
I think I've done the following. When I was the magistrate in Sasolburg, at that stage, you will recall, one could still appoint prosecutors in terms of Section 5 of the Criminal Procedure Act. Because I had a problem at one stage with not sufficient prosecutors being available, I had a meeting with the legal circle and invited them, without being paid, without any compensation, to provide their PAs to act as prosecutors in the district court. After a while, I had so many applications, I could pick and choose between them. So there, for instance, I chose PAs who I thought at the time might be able to, it might advance their careers as far as the legal aspects are concerned. Because sometimes I think one should see what people are able to do. And I got many thanks afterwards because these people were then trained by the senior prosecutor as well as myself as to how you should approach a criminal trial. Then, when I was in Sasolburg, as far as civil work is concerned, I also invited the legal circle to have the clerks as well as PAs to be in the civil court when the opposed motions were done. This, I think, assisted them in how they should deal with opposed motions when they see other colleagues acting in that way. I also, at the time, when I deliver written judgments, I circulate these judgments between all the practitioners. Not that I'm saying that I was so good, but so that at least they know what I know or don't know when they come to court. In the regional court, I assisted several attorneys and prosecutors in as far as a judicial officer can do. I believe a judicial officer is not merely an umpire. You'll have to see to it whether your legal practitioners and prosecutors are on the same level, whether they can do a criminal trial, because justice must be seen to be done. I also offered my assistance to the district court magistrates by circulating my judgments between them, because in most of the cases, judicial officers do not know how to structure judgments. To give them an example as to how your judgment should be structured.
I'm sorry.
Yes?
Did you say most of the time judicial officers don't know how to structure their judgments?
Yes.
And they give them to prosecutors to help them?
No, I was the magistrate then, the regional magistrate.
Yes, and you gave it to prosecutors to...
No.
who?
The district magistrates, I assisted them how to structure their judgments, and when it was newly appointed district magistrates, I assisted them in how to deal with quasi-judicial matters, because I've been in the district court for quite some time. Now, I assisted
you were the
district
prosecutor at
magistrates.
the time.
I beg your pardon?
Your position was prosecutor at the time.
No, I was the regional magistrate.
You were helping other magistrates.
Yes.
Or because they didn't know how to structure their judgments.
They were uncertain as to how it should be done. I was
Yes.
also a mentor.
They were new.
Yes,
Yes, okay, all right. Okay.
mostly acting district court magistrates.
Okay, all right. Okay. I interrupted you. You had finished.
Yes.
Okay, all right. I guess that you haven't had much time to deal with administrative law cases. Is that correct?
Administrative matters.
Administrative law
No,
cases.
I did not.
Yeah. And constitutional law cases.
No, I did not.
Yes. Do you not feel that, to say the least, you would need more acting stints before you could be ready for consideration for appointment? I see that you said you got only a few weeks acting stint.
I think with 35 years as of 1st of March this year, being on the bench, I think I have, as far as possible, sufficient exposure. I dealt with all walks of life. Nobody knows everything in the law. I am a hard worker. I have a zest for life. I'm eager to learn. I know how to do research. So whenever I have to deal with anything, I will do the necessary research and see to it that I know the law applicable.
So, but your experience has not been at high court level, isn't it? you have had only a very limited acting stint in the High Court. Your experience has been at District Court and Regional Court.
That is correct.
But you are applying for a position in the High Court, not in the Regional Court. Shouldn't
is
you
correct.
have sufficient experience at High Court level so that you can cope with the work that you would be required to do at High Court level?
Obviously, it would be the preferred situation if I had more stints at the High Court.
Yes. Okay, all right. JP?
Thank you, Chief Justice, and good evening, Mrs. Venter. It's me.
Good evening, JP.
Yes, yeah. Just one thing. Clearly, you have spent almost more than half of your life on the bench.
That's correct.
Yes, which is quite commendable. And as a magistrate, when are you due to retire?
At the age of 70, I'm 62 years old now.
I see. So magistrate to retire at the age of 70.
Yes,
Okay,
you have the choice between 65 or 70.
I see. Thank you. And then I just want to ask you about the system in the regional court. The introduction of civil jurisdiction in the regional court was, amongst others, entitled to promote access to justice.
That's
So
correct,
that
yes.
not all these cases should go to the High Court.
Yes.
But we seemed to be having a challenge that this case, in any case, coming to the High Court and not to the regional courts. Do you perhaps know what could the reason be?
I don't know, but what I can tell you is that I know of the civil work I've dealt with, a lot of those cases could have been done in the district courts.
It's actually in the district court and not the regional court.
And then all of a sudden it's in front of me.
I see. And one thing that I had noticed is that there would be a need to build capacity in the regional court so that you should minimize the appeals, promote access to justice, and to get the good quality of judgments.
That is correct.
Yeah, I gave you an opportunity to act, and also 3 of your colleagues, so that you should build up that capacity there. Would you see that as a bad
Yes.
thing? Yes. And, but the system as it stands now would not empower you enough for you to be able to practice or preside in the High Court, unless the work is coming there and then you get more exposure.
Yes, and that is why I'm saying if I had more stints, perhaps that would have been better.
Yes.
But in the regional court, you do not get that much exposure to civil work. And as I think you know, we are so busy with criminal trials
Yes.
in the regional court that you barely have time for anything else. That's where I started to start working at 4 o'clock in the mornings. Because my criminal court is so busy that I'm in court every day. And until the end or the beginning of September, I was on a permanent circuit court between 10 different towns.
Yes, no, I do appreciate, and I'm quite sure that you are hardworking and you're doing much. But now the challenge is, if I were to draw you from the regional court and give you a stint for 6 months, it means all those parted matters that you have, because you run your own diet, they will have now to wait for you for 6 months, and some of the accused would be incarcerated. That will be another challenge that will be creating at that level.
Definitely, yes. But
Yes.
at the moment, I'm being assisted by an acting regional magistrate, so they took 5 of the towns away for the acting regional magistrate to do a backlog court.
From the area in which you are operating.
Yes,
Yes, but that would not defeat then the whole purpose of capacitating the regional court, minimize the appeals, and promote access to justice.
I agree.
You would agree. Thank you, Chief Justice. Thank you, Mrs.
Thank you,
Venter.
Judge President. Do you want to try and be in touch with the Premier? Let's see if he has any questions for the candidates.
Is the Judge President speaking to the Premier? Is there no separation of powers in the
Same question. Okay, okay. Ms. Fenton,
Chief Justice.
the Premier has a question for you, and the question is, what is your view about the complaint that we hear from time to time that the judiciary is overreaching? What is your view about that complaint that we hear from time to time about the judiciary?
I believe in the separation of powers, but I think it is healthy in a democratic country that there's a checks and balances system, but don't overreach.
So what is your view? Is that, does the judiciary overreach or does it not overreach?
No, I don't think they overreach.
You had the answer, Premier? Was that your only question? Thank you very much. Thank you very much. Ms. Fenter, thank you very much.
Can I, sorry,
Yes.
CJ, can I just conclude by saying that since 2003 until 2023, I completed 1,820 criminal cases.
Yes.
I had plus minus 21, imposed plus minus 21 life imprisonments. I traveled just under 1 million kilometers.
Yes.
7 cars.
You counted the kilometers as well.
Yes.
Okay. Okay. Thank you, Ms. Venter. We have come to the end of the interview. Thank you very much for availing yourself.
Thank you, CJ.
You are now excused.
Thank you.
Thank you.